Good morning to everybody out there. Thanks for joining today in today's live. We are waiting on motion hearing day for Karen Reed. I am watching it, so nothing started yet, so you don't have to worry about it. As soon as it starts, we will live stream it. So there is a lot of motions on the docket today, apparently. A number of them, some of them have to do with ARCA experts, striking the ARCA experts. Some have to do with striking the dog bite expert for the Commonwealth. So there's going to be a lot to talk about today. So in the meantime, while we're getting ready, let me just acknowledge some of the people here in the chat. We have already a new member, JLB. Thank you very much for becoming a YouTube member for the BC Sidebar membership. Appreciate that. Good morning, Blurry Lights, who is the moderator. So make sure you behave in the chat, or you may get a word or two from Blurry Lights. And good morning and hi to Sybil. And the trial channel is here. Good morning. Good morning to you. Thanks for joining us today. Good morning, Nancy Joe. Sometimes when we say the good mornings, there's some people that are actually, it's for afternoon for them, or it's evening for them, or it's 2 o'clock in the morning for them. So we haven't seen any of that yet because we have an international channel here. So I'll see if that happens. Hello, Justice Jane. Thanks for joining us today. Jessica Lee, nice to see you again here, joining the chat. All right, we got our first international visitor here, Anu Gilstein from Finland. Thanks for joining the live stream. We are waiting on the Karen Reed motion hearing to start, if you're just joining us now. So as soon as it starts, we will live stream it. I'll give you some of my thoughts. How did everybody feel about those interviews that just were dropped? We have the jurors interview, and then we had the interview with Karen Reed and Alan Jackson. Very interesting stuff. My life with Skylar. Hello, Martin. Hello to you. Paula B., good morning. And it is 18 o'clock night here in Finland. So it is evening there in Finland. Here we have Tammy Glassnap-Simon. Good morning. That's right. There's also, thank you for reminding me, Leah Wilkie Donnelly. Good morning. I hope we get some better action today. That's also another motion to admit Mark Betterow as part of the team, the defense team, the A team, the dream team. So we'll see some of that motion practice as well. Motion to admit pro hoc vice Mark Betterow, who, as you know, is supposed to go on a channel with him together. We're supposed to, for the first time, I know people have been asking for it, that I should get together with Mark Betterow and talk about the Karen Reed case. And he was scheduled to be with me on a video on a channel, and he had to drop out because of the updates, because he's about to join the dream team. So that's why we're not able to do that, but he assured me that we'll be able to do that after his job is complete. That's another motion up. Good morning, afternoon, chat. Tammy Glassnap-Simon. And good morning or afternoon in Jerusalem. I actually just had a meeting, a Zoom meeting with another person from Jerusalem. So, and we have Germany here. Hallo, Rose with a Boom. Slovenia, Pikachu, 17 there. Jessica Lee, the juror interview. Yeah, wasn't that juror interview very interesting? I think that surprised a lot of people what actually was going on in the verdict room. Never ceases to amaze me sometimes what the jurors actually base their opinion on. You can be working so hard sometimes on a theory. During the case, you're trying to bring it home, and you're trying to convince the jury of a certain theory, and they'll decide something in the jury room in deliberations, and it had nothing to do with anything that you were concentrating on during the case. So that juror interview was really interesting and eye-opening. So definitely everyone should take a look, watch it. It's posted on Turtle Boy's channel. Right near the action, Marianne Kadabig. Hi from Boston. Right near the action there. Morning from NorCal, Leslie. In Idaho we have, good morning from Idaho. Anybody here from Michigan? Or is it just me going solo from Michigan? Needed that dark room, BC, after the juror interview. Yeah, you always got to have that dark room handy for introspection. Decide whether you're a grifter, take the grifter test. Joanne Keefe, good morning from very old and windy day, New Hampshire. Crybaby 23, much love from Rhode Island, Brother Counsel. Thank you very much for that love. Appreciate it. Rhode Island. And Ashley Rose, good morning from Massachusetts. I understand it's very cold there in Massachusetts. So as we're waiting on the Karen Reed motion hearing to begin, which it is starting right now. So here we go, guys. I'm going to start it right now.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Laura. David Giannetti for Karen Reed.
Good morning, Giannetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
Well, it looks like we're starting off with a sidebar so we can get through some more good morning. So we had a good morning to Ashley Rose from Massachusetts. We had Chloe's mom. Good morning. Today should be good. Today's probably going to be good, but it may take some time, like all the things in this case takes time. So we may be taking some time here as well. So get comfortable, get a good drink with you or something. The glare is here. An honor for you to join us today. Appreciate that. CCL Montoya. Good morning from New Mexico. We have South Africa here. And we have Central New York. It's supposed to be snowy and cold, and that's how it is here in Michigan as well. So that's just life in the Midwest. Probably life in Massachusetts also in the winter, and New York. You're going to feel the cold. Summers are nice, though. I bet you it's a little bit nicer in Texas. So hello from Texas. WIG from South Jersey / Philly. Good morning to you. We're getting close to the afternoon, but it looks like the sidebar is ending. So I'm going to
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you said?
They'll have it on or before March 1st.
Okay.
So that was the motion for the records from Boston 25. As we know, all these interviews that were being done. So he wants all of the, remember, off the record notes, and there's been no opposition to that. So that's going to, very easy motion when there's no opposition. So that's going to be granted. just like we have with Gretchen Voss. So he's going to get all of the records from Boston 25 of the interview with Karen Reed.
All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
I'm sorry, the opposition to
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506.
Great, thank you.
That's the response.
Right. Okay, who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice brought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer had the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after, because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process, because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today it'll be done by the end of the week.
You want to maybe, I'd be heard briefly,
Yes,
very, very briefly.
take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. We're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want
That
the
October 24th,
fourth.
did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. What's the metadata associated with all those things? It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just gonna drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
So basically, that's this argument is just that they should get the metadata. I mean, what's the big deal? No, you want to provide the actual video, right? You got to provide the video, okay? But he agrees about that. And now the defense just wants also the metadata associated with that video, which they're entitled to. They're definitely entitled to that. There's no argument about whether they're entitled to the metadata. Brennan didn't say they're not entitled to the metadata. Why are they not entitled to the metadata? So that's all. Just do it the right way. For the first time in the case, do it the right way. That's all he's asking for. And that's why it helps to hear the history about how every time that they get a video and it's a new video and then there's no more video and then there's another video and then that's it. There's no more video after this and then there's another video and now there's another video. So let's just do it right this time. Let's do it 100%, dotting all our I's and crossing all our T's. Let's just get the metadata. I can't imagine that Judge Cannone would deny this motion.
Further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something.
Yeah, they invited them after the guy already spent $12,000 to send a guy there on a wild goose chase. And now we invited them again. Just come again for another $12,000 and do it. Like, we're so accommodating.
Something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Well, what you can do is do it right. That's all they're asking for. Why do they have to be there to babysit you? Why do we have to hire our experts to go down there and make sure that you're doing what you're supposed to be doing without us looking over your shoulder? That's the point. Just get a forensic person who knows what they're doing to download the data in the forensically appropriate way that will preserve all the metadata and preserve the logs and just turn it over that way. Why do we have to babysit you? That's exactly the point.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hoc Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
So apparently they need a more. She needs a more detailed affidavit of why Mark Betterow should get involved in the case. So she's not just granting that motion willy nilly. Although she did say, just fix up that affidavit a little bit, give some more context, get some more reason why, you need Mark Betterow on this case, or you want Mark Betterow on this case. You got already some very, very qualified lawyers there. Just give us a little bit more, and then they'll grant the motion unless Brennan opposes it, which doesn't seem that that's going to be the case. By the way, I'm not sure where he's going to sit, Mark Betterow. I mean, look at that table. There's no room for anybody else to sit.
Thank you, Your Honor.
Okay, the next one's paper.
Maybe her brief.
Yes,
Maybe her brief.
yes.
Oh, so maybe there's going to be opposition.
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Bedero presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay.
I guess no response.
Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Court. Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer, make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide that copy if you want.
Yes. All right, so this is,
They've never objected to anything about anything that Karen Reed has said to any of the journalists. They've never made any sort of objection. And what they're trying to show is that we don't care. There's nothing we have to hide. You can get all the off the record statements also. Go ahead, have at it. There's nothing that we have to hide. They've never objected to, from what I remember, they have never objected to them getting any sort of audio or transcriptions or notes from Voss or any other journalists that spoken to Karen Reed or their attorneys.
allowed. All right, so the next is paper 490, Defendants Rule 14 and 17, motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at One Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit.
So they want to get their own, this is Karen Reed trying to get their own accident reconstructionist to look at that driveway, One Meadows Ave, and see the Traverse and run some tests. And they also made a mention in there that the O'Keefe family should not be within 200 feet of that testing, because apparently when the Commonwealth was doing some testing, the O'Keefe, I think it was Paul and his friend, were able to be there. So they pointed that out. So we'll see what they have to say about that.
From attorney Mark Diller on behalf of the O'Keefe family in response to Defendants Rule 14 and 17 motion for court order authorizing defense access to the Lexus and Traverse into the driveway at One Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's a spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly in.
Okay, so what's going on here is this is a motion that ruled that when the defense has a witness that they are cross-examining and they have some sort of document or some sort of impeachment material, maybe that's a transcript, maybe it's a grand jury transcript, maybe it's a federal grand jury transcript that they are going to want to use to impeach the witnesses, that the defendant, Karen Reed's team, has to turn over that information to the Commonwealth. Okay, so basically, you're taking away any of the surprise, and you're also allowing them plenty of time to figure out how they're going to deal with these lines of cross-examination. If you get a witness on the stand and all of a sudden the witness is saying one thing and you've got a document which completely destroys them, and you say, hey, take a look at this document, and then it just completely destroys them, well, then they don't have any way to prepare for that. So, but what Judge Cannoni has previously ordered is that basically taking the surprise out of all of this, they've got to turn over any sort of impeachment material that they're going to be using on cross-examination. And Yannetti is saying it's just not fair. I mean, it takes away the surprise, takes away the teeth of cross-examination. So he's asking her to reconsider that order, which, quite frankly, I haven't had to do this. I don't remember having to turn over my impeachment materials, exactly what I'm going to be using. Now, it could be that they would have access to these materials the same way I did, but I don't have to say, look, these are the materials I'm going to use against your witnesses. So again, he's asking to reconsider. So he's got some sort of case law that also says that since it's taking away the surprise, you don't have to turn over these impeachment material.
An accusing witness with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outlined in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to Ms. McCabe, it was never mentioned anywhere that she spent an hour at the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. And, I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But, we also make the point that with regard to, Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions. Understood.
All right, so Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes their names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, and control, I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways. Federal rules are very different. In state court, for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right, thank you.
So apparently another piece of evidence that was turned over late in the game after Jennifer McCabe testified. There's some sort of report of her meeting with Lank, and that also wasn't turned over. So add that to the list.
Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth, paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that's still outstanding. There's 10 items. I'll address those in turn. The first request deals with.
So you have the Commonwealth's response, right?
Yes,
Where it doesn't object to some. Are you going to skip over those? Or
yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those reproductions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handle this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these 2 cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by 2 material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore, no evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. This clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth.
Look, what's good for the goose is good for the gander. You gotta be both ways, right?
And its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right, Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded, touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case?
How about the cover up of it? What about that? Doesn't it have something to do with this case, perhaps? Maybe some links there?
Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady versus Maryland in Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth versus Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA. And again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week. And I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
And by the way, that first request, I know it's a little bit tedious there going through all the different things that they want, but that first request that the defense wants, which is the logs and the chain of custody, they know that doesn't exist. The defense knows that doesn't exist. This is just simply setting up their Brady motion, their motion to dismiss, because they want Brennan to say they don't exist. That's what they want. They want to get, but in order to really make that motion much stronger, that motion to dismiss, which is coming, they want to tell the court, look, we asked for all this stuff, all this chain of custody, all the logs, the metadata, anything associated with those surveillance videos in the Sally port. We even had a motion to compel on it. And Mr. Brennan here said to the court, in open court, these things don't exist. And we can't manufacture them. We can't create something that doesn't exist. That's exactly the point. The point is that they don't exist and they should exist. The fact that they don't exist is exactly why it's Brady. It's Brady material. It should exist. They should have preserved it in a way that they do exist. There should have been a chain of custody. That's absolutely Brady material. So this is really just, that first request is really just to set up everything coming up in the motion to dismiss. I think they really know that it doesn't exist, and they just want it to be very clear. They want the record to be extremely clear, in case Judge Cannone denies this, that there was no question that this did not exist. And if it didn't exist and we asked for it, the reason why is that the Commonwealth didn't do their job. The police didn't do their job. And therefore, all this, you have a duty to preserve. You don't need any special request to preserve. This is what you're required to do. You have to preserve it even without any sort of request, formal or informal. Doesn't have to be requested. So that's really what they're asking with the first thing. Now, the Sandra Birchmore stuff, that these are the same officers that are investigating it. It's very clear that there's allegations of a cover-up, and therefore, for discovery purposes, for sure, they should be allowed to discover that stuff. Whether it's admissible is another question. But just the fact alone that there's been allegations of a cover-up doesn't mean that that has to be proven. It doesn't have to be proven for discovery purposes. There's allegations of a cover-up, and the same police are associated with that case, and they're associated in this case, and the same allegations of a cover-up or preferential treatment to police officers, that itself should be reason why they should be able to get the reports on those cases, the notes on those cases, the documents associated with that case. So we'll see what Judge Cannone eventually does on that.
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, we're over 500 at this point. So.
Yes.
All right. All right. So next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan.
And this is the most important motion of the day, probably.
Sure.
Your Honor, my purpose is not to deprive the defense of an expert
Really?
or deprive the defense of an ARCA expert in this case.
That's what they're trying. He's been trying to strike every expert in that they have. But that's not his point. His point's not really to deprive them of the experts. Yeah, well, I tried to strike Dr. Russell. I tried to strike Richard Green. I'm trying to strike the ARCA experts. That's not my purpose. My purpose is not really to deprive them of any experts, even though that's exactly what I've been trying to do for the past 3 months. But okay.
But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent the best I can to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
All right, please.
Well, that's very, very, very interesting. I thought I heard that Alan Jackson paid them for $23,000. Now, what's possible, this is just me, and I don't know why she's taking a break now. Usually you don't take a break after one side gives the argument and you don't hear the argument from the other side. I'm not sure what's going on there. But that is some really, really breaking information right there. If there's some sort of bill that was, and I'm assuming we're going to hear from Alan Jackson some explanation here about what happened here. So it seems that there was some sort of emails back and forth between Alan Jackson and at least that was Dr. Wolf. It seems like that was Dr. Wolf. And some outline of questions and some sort of strategizing, it seems like. So that's very interesting. And now they have this bill, $23,000 bill. Let's see what happened there. Now, this is just me thinking out of the box. I don't know, and we haven't heard from Alan Jackson, so maybe I shouldn't even speculate what he's going to say, what happened. But I'm assuming there's going to have to be some sort of explanation. But this is interesting that this is all this information coming out now. This is really, really interesting. So we're going to have to see what it is. Okay, I paused it. I probably shouldn't have paused it. Yeah. Well, wow. This will be very interesting. Wow, wow, wow. I'll put your questions in the chat if you want to talk about something. A very different understanding that we have now. So here's the deal. Okay, if Alan Jackson really hired these attorneys, there may be some questions about his representations, that they're independent, that they're objective, that he didn't pay them anything, things like that. But generally speaking, the way it normally works in trial is that you have to hire your own experts. And sometimes your experts are very expensive. Okay, if you guys, let me just explain, because it seems like some people are a little confused. I see from Jessica Lee, I'm confused what just happened. Okay, so let me just try to explain what just happened in case you missed it. The whole idea here, the whole premise of Alan Jackson was that these ARCA experts were provided by the federal government. They gave them a report, and that's all the information that they were able to have. They weren't able to have any contact with them. They didn't pay them. They were paid by the federal government. They have absolutely nothing to do with. They weren't able to interview them or talk to prepare their testimony before the trial. That's all things that normally happens. When you hire an expert, you can prepare with that expert. You pay that expert. You have conversations with that expert. You have notes, you have emails, you have text messages with that expert. So that's what normally happens. Now, the ARCA experts, since they were from the federal government, Alan Jackson has been saying, the defense has been saying, that we don't have any sort of interaction with them. Very, very limited, just in terms of, scheduling, when can they come and things like that, but nothing really strategizing, nothing about trial strategy, which is what you normally do with an expert, which creates this idea that these are really, really independent and objective witnesses. Okay, that was their position. Now, Hank Brennan just got up there and said by following up with the federal government many, many times, he was able to get some more materials from the federal government. And he got some emails that were between Dr. Wolf, it seems like, and Alan Jackson. And in those emails, it definitely looks like there is some sort of strategizing. They're talking about certain questions, what to ask. I don't have to mention this. I don't have to mention that. Maybe I could explain this if you don't want me to, if that's not going, it seems like they were actually talking in strategy. And then there's some sort of bill for $23,000. So are they hired by the federal government? Is the federal government one that's paying them? Or is this Alan Jackson paying them? So this is earth-shattering to anybody who's been watching. This is the first time that we're hearing anything like this. I didn't see this in the motions. So this is just earth-shattering, and that's Hank Brennan's problem. If you're trying to hide information and then you're going to try to argue that they're objective, and really you're only able to argue that because we don't know this information that you're not turning over, well, that's improper. So really, really throwing a curveball here into all this. So really very interesting stuff. Now, I will say this. Okay. In 99% of trials, you have experts that are hired by either side. You have experts that are hired by the defense, and you have experts that are hired by the Commonwealth, or experts hired by the plaintiff. And they're hired, and they get on the stand, and it's very clear that they've been hired. They can still be very effective, even if they're hired. So, yes, you can argue to the jury that they're biased. You can argue to the jury that they're not objective. But that's what happens in 99% of the trials. And if one side has an expert and the other side doesn't have an expert, even the one that has the expert, even though they paid them, generally speaking, that they're going to be very helpful to that side. But here it seems that Brennan's going to have his expert also. Now, Brennan probably paid his expert as well, and that's going to come out. So you're going to have some sort of battle of the experts here. I really like to hear what happened here with Dr. Wolf, and I didn't hear much about Dr. Rentschler. So we're gonna see if there's any sort of email correspondence with Dr. Rentschler as well, and maybe there's some sort of agreement or agreement or retainer. But this is really a big change in this case right now. Very, very interesting. And you guys, you can put some questions in the comments if you want. We're waiting for Judge Canoni to come back to the bench to see what she's going to do with this. I don't know why she took a break right now in the middle. It's very strange unless she has some sort of stomach issue. But right in the middle of this type of argument, very, very interesting that she would take a break. Here's from Nikki. Yes, I feel misled and not going to lie. If that's your feeling now, that could be true. But though I will say that you gotta see what the explanation here is. We didn't hear the other side, which is strange. Like I keep saying, we got to hear what Alan Jackson has to say back to this. There could be some reasonable explanation. Maggie Ray's brother counsel, don't you find it strange that Hank didn't have dates on there? And if you're talking about the emails, he did mention some dates. He mentioned March 22nd. He mentioned June 22nd. So there are some dates that he mentioned. I have to go back afterwards. And the other Karen, I owe you lunch. Yes, you do owe me lunch. I've been waiting. My PayPal. So let's go. And by the way, that has to do with the bet about the SJC opinion, which I was right about. So here's Brian Jr.'s frozen donuts. Who gives of who hired them? Either way, their credentials speak for themselves. That's true. It's an argument to be made to the jury. That's all. That's the point here. The credentials speak for themselves. They're not going to perjure themselves on the stand. They're not going to just make things up. You can definitely show some bias. So the Commonwealth, you can argue that there's bias with the ARCA experts. That's the argument that will go. That doesn't take away from their credentials. It doesn't take away from their opinions. You can say that they're a little biased, but if they're saying directly, and this is what usually happens in 90% of the cases, when you have someone who's actually paid and they're still saying with a straight face, look, the science and physics don't add up. So then, they're saying that directly. It's not just trying to spin something or make something seem a little bit more extreme than it is. So their credentials still speak for themselves. They're still Ohio credentialed. They're qualified. And and how strong they say their opinion and what they're saying in their opinion still has to be considered. Marty Velasco, brother counsel, if you watched the Four Nations face-off game, Canada versus USA was one of the best games I've ever watched. I also played. Oh, you played hockey, I guess you mean. I did not see the entire game. I know a lot of people saw it, but I'm a little busy. So I was not able to see. I saw some highlights, though. The other Karen, here's a question. Maybe I shouldn't read questions until I get my bet paid off, but we'll do it anyway. Can Bev eliminate these experts? Well, that's exactly what Hank Brennan's asking her to do. He's saying they did not comply with their Rule 14 obligations, and therefore they should be excluded. Well, here we go. That's exactly what she's asking for. He's asking for. Here's Nicole 77. I have a feeling a Daubert hearing is coming for ARCA. I don't think this is a Daubert issue. This is not a Daubert issue. This is an issue of Rule 14 discovery violations. Here's a question, Michelle. Wouldn't their expert opinion naturally create bias for the defense since they're saying there wasn't a car accident? Yes, that's true. It does create a bias for the defense, but the question is if they have a bias, a personal bias towards the defense. Do they want to help the defense in any way, for any reason? Are they repeat clients of the defense? Are the defense paying them? The defense is paying them $23,000. Well, then that can be used to show that that's why they want to help that side. When you're getting paid by one side, you want to help that side. That's the reason. Now, of course, their opinion is definitely biased towards the defense, but if they're coming from an objective place, it's much stronger of an argument to the jury. But if you show the jury, these are people that are being paid by Alan Jackson. Again, we have to get some more clarification about this because we stopped in the middle of the hearing. But if they can show that Alan Jackson paid them $23,000 to testify, well, then you can bet you're going to hear that a lot. You would hear that during opening if it was me. You'd hear it during closing and say that these ARC experts can't be believed. Jessica Lee, is Canoni going to be mad about that? Again, there has to be an explanation here. And yes, she's going to be mad about that. Any judge is going to be mad about that unless there's a good explanation. So a good judge is going to allow Jackson to pick it up and the judge is going to say, well, Alan Jackson, what's with those emails? Why weren't these ever turned over to the defense? Go ahead, explain yourself. So you're going to have that due process, but let's see what happens. Okay, Jessica Lee, how did Brennan find out that they were paid? He made a request to the federal government. He made a TUI request. And he had to follow up, and dealing with the federal government's not easy, but he knows a little bit how to deal with it. By the way, this is why I keep telling you guys, Hank Brennan is a good attorney. He knows what he's doing. This is why he's hired. This is all the type of stuff that the regular prosecutors at the DA's office wouldn't probably know how to do, or wouldn't be strong, continue to follow up with these type of things. This is what he's getting paid for. And Brooklyn, he didn't pay them to be biased, just to do an accurate report. And yes, so that's exactly the argument that the other side makes. The side that has to hire an expert, okay, this is the way it goes in all trials. The side that hires an expert always tries to tell the jury, look, you don't like working for free. Neither does this expert. Why should he come in here, waste his time and testify and write reports for free? Of course he works for money. That's how everybody likes to operate. Nobody likes to work pro bono. I like to get paid. All of you like to get paid. So does he. Does that mean that we can't trust his opinion? How many times do you pay for things and you trust the people that you're paying for? You go to the dry cleaners. Are you going to expect them to clean your clothes for free? Otherwise, you don't trust it? Of course not. You go to a mechanic, hopefully one that you trust. You pay him for fixing your car. Does that mean he's not trustworthy to fix your car? You go to a doctor to get treated. He's going to charge you. Nobody works for free. So is the other side suggesting that our experts work for free out of the goodness of their heart when they can right now, instead of be wasting their time in trial, they can be making $500 an hour doing something else and making money? Why would they do that? Nobody does that. So of course, that is the argument that you argue to the jury. What's more important here, I think, is that number one is that, okay, that takes a lot of the wind out of Alan Jackson being able to say that they're independent. But the more serious issue here is that there was a discovery violation. This was materials. This was things that Alan Jackson, it seems like, at least this is what Hank Brennan is trying to say here, was suppressed and was not turned over. That's more of a problem, at least for Alan Jackson and this defense team now, than having to figure out how to argue to the jury that just because they're getting paid doesn't mean that they can't be honest about their opinions. That's the last thing that they're worried about right now. Here's Marty Vale, Esquire, fictional broad counsel. What position do you play? Because we're talking about hockey. I play forward, sometimes center, sometimes wing. A possibility here is that the federal contract ended with them, and they said, if you want to hire us, you can hire us, but we're not going to show up just based on the federal investigation, but you have to pay us, and that's what happened. But again, it should have been turned over. That's the question right now. Was none of this stuff turned over? And remember, the whole defense's argument, a lot of the defense's argument here is that the Commonwealth is not turning things over. So the Commonwealth can say, hey, you're doing the same thing. Don't throw rocks in a glass house. And Brittany Gibbs, let's hear the other side before assuming this is true. LOL. Yeah, I mean, we should. We definitely have to hear the other side. Again, this is why it's so a little frustrating that Judge Cannone just decided to walk off the bench in the middle of this argument. So, what's the other side? Let's not jump to any conclusions. I don't want to. Here's Jessica Lee. Don't all experts get paid? Yes, and 99% of the time they do get paid. Absolutely. I mean, I don't know what's going on. I mean, like, usually, you'll say, okay, we're going to take a brief break. We're taking a lunch break. How long is this break going to be? What in the world is going on now? I mean, Here's a question by Nikki. I missed your commentary on Brennan's reaction to Betterow joining Karen Reed. What did you think about that? Brennan's reaction was, obviously it's a very important right for a defendant to be able to choose any counsel, but because Betterow represents Turtle Boy, and there's here we go. We got to stop because we got to see what's going on right now. I mean, this is nuts.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Your Honor, if I may hand up the discovery that was
Thank you.
provided by the defendant reference card.
Oh, great, thank you.
Is there any way we should suspend for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
Ma'am, just a moment.
Thank you.
So this actually seems to be true, that the emails are from this year after the contract ended with the federal government, and each side was free to
Your Honor,
do it.
we'll accommodate the 25th, one way or the other.
All right.
25th
So we'll see
fine.
everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
11 o'clock. Okay, so now all of a sudden it seems a little bit different. Seems now that the defense was the ones who provided those emails and that retainer agreement of the expert with to the Commonwealth, to Hank Brennan. So I'm a little confused myself exactly what just happened. So I got to go back and I have to see what exactly Hank Brennan was talking about, and now how at the end he seems to be saying that the defense sent them these emails. So the only other, I thought what he was saying was that in 2024 they had these email exchange. So it's possible, again, this is just, I have to go back to double check the dates here, but it's possible that on 2024, that's what Hank Brennan was talking about, where there was some email correspondence between Dr. Wolf and Alan Jackson. And if on the if in 2024 that happened, and that was not turned over, that may have been a violation. And there can be implications for defense counsel as well as this case. That's most likely what Judge Canonia was referring to. This is why she put a stop to this right now. She's not allowing any sort of other arguments. So, yeah, we have some sort of, and what I've got my notes here also, and I see that Hello Sunshine said it was March 2024. That's what I have here. That's what I wrote down. March 22nd, 2024. There was some sort of agreement or some sort of email exchange. And then on June 22nd, 2024, there was some outline of questions or things like that. So that's where this gets a little sticky for the defense. So to make, and I'm going to go back to double check this because I'm just a little confused myself. But what my understanding is that even though in 2025, the defense seemed to have hired them, which is completely fine because their contract with the federal government ended in 2025, in February 2025. And therefore the defense is free to hire them. Seems like they did. But if there was conversations and emails in 2024, when Jackson has said in open court that they have no information back and, they have no correspondence with them, and it was just simply about arranging a time, and he was really not turning over this information, there can be serious implications. Implications in terms of the attorney, Alan Jackson, if he's not abiding by a court rule, if he was representing in court something that's not true. That's a problem for a lawyer. You can't do that. And that could have implications on his license. So, that's just, and again, nobody wants to jump to conclusions. I'm not jumping to conclusions either. But this is all probably what's going through people's minds now about if he knew about that, which he did, most likely. If this email what's the explanation to these emails? What's the explanation to these outlines that was going on? The outlines of the questions and strategizing with the other side. Now, even if they're not hired at that point, even if 2024 they were not hired by the defense, but if you're working in tandem with them, you're working on your strategy with them, then that can be a problem. So that's why this all just completely went off the rails. Brandon Nung, thanks for the $9. Guess no question there, but appreciate the support. But yeah, this is turning into much more of a circus than it already was. So, which is probably the right move for Judge Cannoni. I mean, to just stop everything right then and say, okay, maybe Alan Jackson wants to be represented now by his own attorney before making any sort of statement in court, which could be the right move. Before you get up and try to explain yourself, maybe you want to hire counsel yourself. So that could be, but this is this is a little crazy. What's going on now? I mean, this case is just nuts. Wow. So, okay, we're going to have to definitely do a recap on this. I would have to do a recap on this, but I really want to see those very, very carefully again. What happened? Okay, here, let me just play this. We got Brandon Nugg. You cut it off too early. Alessi confronted Brent at the end. They did speak. I saw that they spoke together at the end. I don't know what they were talking about. You couldn't hear what they were talking about, and I was watching. They just spoke together, so we don't know what was said or anything. But I think this is a good way to explain it. Annabana, cliffhanger. And then Brittany Gibbs, feel like we're being lied to. It's possible. I mean, this is just wild. It's just wild. What was really going on in 2024 between these ARCA experts? And can you imagine? I mean, think about it. You didn't need to suppress this information. Even if you would have hired the ARCA experts yourself, which they were going to do for 2025, it seems like, for this retrial. In that first trial, I understand why you want to say that they're completely independent and objective. And he said that a number of times in his closing arguments, as we all know, as we all remember. But if they're not completely objective, and you know that as a lawyer, and that's what you're presenting to court, it's a problem. Representing to a jury, that's what you're arguing to the jury. Problem. So, you didn't really need it. I don't think he needed that. I think the ARCA experts were so credible. They're so qualified. Even if they were hired by the defense, who cares? That's how it usually is done. It's not, and that's why now, if you imagine for a second that the ARCA experts gets that they're struck. Imagine that they get struck now. Okay, just imagine for a second. And Karen Reed now has to go on trial because her attorney got these ARCA experts struck without ARCA experts. That's not a pleasant place for Karen Reed to be either. So she needs those ARCA experts. And if the reason why the ARCA experts aren't allowed in is because some Rule 14 violations by her attorney, that's a big problem, to say the least. So, wow, this is just nuts, and I'm sure everyone's reacting the same way. So, in a week, we'll have some better answers, I guess. But this is really unbelievable. Okay, so I guess that's going to be it for now. I'm going to most likely do a recap and watch this more closely and make sure that we understand the dates and what exactly Brendan was saying. And we'll see what happens next week. So that's it for now. Thanks for joining the live stream, but looks like it's ending now because we got to all digest this and figure this all out. But some pretty crazy stuff. All right, guys. Thanks for joining. And we'll see you next time.